One of the crown jewels of the civil rights movement is the Voting Rights Act. It was signed into law by President Lyndon B. Johnson while surrounded by civil rights leaders like Martin Luther King, the late Congressman John Lewis, and many others. It happened in 1965. It transformed American politics. At the time, Johnson called it a triumph for freedom as huge as any victory won on any battlefield. It was a step toward making good on the promise of the constitutional guarantees that were outlined by the 14th and 15th Amendments about equal protection under the law. It was a key part of ending the Jim Crow-era policies of the day, which kept black people out of Southern politics. It aimed to ensure that states could not disenfranchise black voters. For many years, the Voting Rights Act was reshaped and expanded to protect a broader swath of Americans: Spanish speakers, Native Americans, disabled people, minority voters, all across the country. And it was successful. Over the years, it also improved representation in government. The number of non-white representatives in the House increased dramatically. Pew Research reports 28% of House members are black, Hispanic, Asian, or Native American. We've gotten so used to polarity that has become the American politics, but the Voting Rights Act for a long time actually had bipartisan support. Here's the Republican president, George W. Bush, reauthorizing the Voting Rights Act in 2006. It was thriving. It was a win for both parties until it wasn't. In recent years, the Supreme Court has chipped away at crucial sections of that civil rights law. In 2013, in a 5-4 vote, the Supreme Court struck down Section 4B of the Voting Rights Act, ruling it unconstitutional, which then weakened Section 5 as well. These are major blows to the Voting Rights Act. Section 5 established a process known as pre-clearance. Now, pre-clearance is a formula for the Justice Department or the D.C. federal court to pre-approve any changes to voting laws that are proposed by states that have histories of discriminatory policies. So for decades, it blocked racially discriminatory election rules, including gerrymandering and voter ID restrictions. By striking it down, 9 states, mostly in the South, were then free to change their election laws without advance federal approval. In her scathing dissent, Justice Ruth Bader Ginsburg wrote, quote, "Throwing out pre-clearance when it has worked and is continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you're not getting wet." There's now essentially one remaining pillar of the Voting Rights Act. It is Section 2. It outlaws election practices that deny or limit voting rights based on race. It applies to election practices like racial gerrymandering, ballot access, and voter registration restrictions. On Wednesday, the Supreme Court heard oral arguments in a case called Louisiana versus Calais. Now, decades of legal precedents have in practice directed states and federal courts to ensure that legislative maps contain some districts where minority voters make up at least half of the population. The rationale being to prevent the diluting of minority voting power and to ensure fair representation for communities of black, Latino, or Asian voters. What's happening in the Louisiana versus Calais case is this: a group of white voters in Louisiana is challenging a congressional map that has created 2 majority black districts out of 6, 1/3, in Louisiana. Okay, the two are, it looks like one big purple line, but it's actually 2 districts. This map was created in line with the Voting Rights Act in order to not disempower black voters who make up 1/3 of Louisiana's population. But the group of white voters argued that the map is racist against them. After oral arguments this week, several of the conservative justices signaled their willingness to strike down Section 2 of the Voting Rights Act, which would essentially legalize gerrymandering by race, allowing Republicans to pick up an estimated 19 congressional seats in the process. Dismantling the Voting Rights Act has been a long game. Its opponents have long found a champion in the Chief Justice of the Supreme Court, John Roberts, dating back to the 1980s. He was a young attorney in Ronald Reagan's Department of Justice. He fought against expanding the VRA. When he was nominated to the Supreme Court by President George W. Bush, Congressman John Lewis, who nearly died marching for voting rights in Selma, Alabama, testified against his nomination. Congressman Lewis said, quote, "Had Judge Roberts' narrow reading of the Voting Rights Act prevailed, fewer people of color would be serving in Congress and at both state and local levels today." And so it comes as no surprise to those who've been following his career that as Chief Justice, he's prevailed over the historic dismantling, piece by piece, of the Voting Rights Act, a project that will likely be nearly fully realized when this court rules on this latest case. Joining me now, Elie Mystal, justice correspondent at The Nation, where he writes about the courts and the criminal justice system. Elie is also the author of Bad Law, 10 Popular Laws That Are Ruining America. Elie, I have a lot of specific questions, including questions about how this case is going to end up. But I first just want your take on this, because for a lot of people, this has become like the air we breathe, right? The Voting Act was something, they thought certain things were fixed, and now we are literally going back to 1964.
The Voting Rights Act is the most important piece of legislation in American history. It is the thing that makes the promise of America, the idea that we are a fully fair and equal society with equal political participation. It is the thing that makes that idea real. Before the 1965 Voting Rights Act, this is an apartheid nation where Black people are not allowed political power and representation in the country. After 1965 Voting Rights Act, we are something approaching a democracy. So that is the demarcation line. And John Roberts has been an enemy of the Voting Rights Act, as you pointed out in your opening, for his entire career. John Roberts is the biggest enemy towards Black people that this court has seen since Chief Justice Roger Taney, who authored the Dred Scott decision. Now, white media generally doesn't talk about him like that because he's a genteel man. You know, he's not running around letting his flag fly like Sam Alito, but make no mistake, whenever Black people are asking to have equal representation of this in this country, John Roberts is the man standing at the door telling us no. He is the problem, and we're going to see that play out in Louisiana versus Calais when that decision comes down later next year.
So let's just talk about the concept here. The idea is Black people make up 1/3 of Louisiana, so why wouldn't it be fair to have 1/3 of the votes? It's not suggesting that those have to be Democrats, right? It's not suggesting that Black people are a monolith, and that if a district that has more than 50% of a minority population gets to have that district, that it's only going to be Democrats. At that point, in a fair system, you would say to Republicans and Democrats, compete for those Black people's votes.
Exactly. That's the whole point of it, right? Like, understand this case and gerrymandering, voting rights gerrymandering cases in general. This is not about Black people like asking for anything. It's not about Black people asking for more than their share. As you pointed out, Louisiana is 1/3 Black. They have 6 congressional seats. Simple math. I mean, you don't need to be a Neil deGrasse Tyson to understand that 2 of 6 is 1/3, and we should do that. What the white people in Louisiana are arguing for and asking for is over-representation. Right. They want more representation than they deserve. White people only make up 56% of the population in Louisiana. They want more representation than that. And it actually came up during the case, Allie, that the lawyer defending Louisiana's maps argued that, well, if the people that we were disenfranchising had been white Democrats, everything would be the same. Louisiana would have done the same thing. We were discriminating based on party, not based on race. That was a key argument from Louisiana, because John Roberts has previously said it is okay to discriminate based on party, but not necessarily okay to discriminate on race, right? But again, Allie, we have math here, right? And the math in Louisiana and quite frankly across the South shows that even white Democrats will not vote for a Black candidate. White Democrats would rather vote for a white Republican than a Black Democrat in Louisiana and all across the South and in general all across this nation. So if Black people are to have representatives that look like us, whether those representatives be Republican or Democrat, you kind of need to have majority minority districts, because white people won't vote for a person of color no matter what party they're running in, generally speaking. And that is one of the reasons why you need 2 minority-majority districts in Louisiana to counteract that problem.
There's this weird concept that goes around that somehow the founding fathers and the document that they produced, the Bill of Rights and the Constitution, were colorblind. That's actually not true. That's gaslighting. But it now persists in this issue of affirmative action, and now this case, in that you can't consider race to adjust for racism.
The core of the conservative argument is that you can use race if it's helping white folks, but you can't use race if it's stopping white folks from taking advantage and disenfranchising Black people. And here you mentioned Section 2 of the Voting Rights Act. That's the thing that is currently on the chopping block and most likely will be taken away. one of the really important functions of Section 2 is that it doesn't require a showing of intent, which is to say, if we can look at a state, a map, a gerrymandered situation that has the outcome of discriminating against Black people, we don't have to also prove that that's what Louisiana or some other state intended to do, right? They don't have to say, like, we trying to do some racism today before we can just look at the results and say, like, you know what? You know, Louisiana might say, I don't have a racist bone in my body. Doesn't matter. If the outcome is racist, then Section 2 is allowed to operate. And that is the core of what they're taking away. One of the pegs that he always hangs his hat on is that unless litigants are in his courtroom openly saying they intend to be racist, Roberts pretends that racism doesn't exist. Like, you literally have to. At one point, Janae Nelson, who was arguing the case for the NAACP Legal Defense Fund, Janae Nelson said that the Voting Rights Act requires neither a confession or an admission. White people don't have to confess to what they're doing, nor admit it. We can just look at the outcomes. And that is exactly at the heart of what Roberts is trying to rip out here. He's trying to say that unless there's intent, unless white people self-report as being racist, you cannot use laws to stop them.
Elie, thanks as always, my friend. Elie Mystal.
That is the core.
Elie Mystal is a justice correspondent and a columnist at The Nation. He's the author of Bad Law, 10 Popular Laws That Are Ruining America. All right, coming up, Bean.